Welcome to a deep dive conversation with another important topic for U.S. visa aspirants. Today we're cutting through the noise around U.S. work visas. We're going to focus on one that's quietly becoming a bit of a game changer for top talent, the O-1 visa. If you've ever felt kind of trapped by the H-1B lottery or maybe thought a U.S. career was out of reach, well, this conversation is definitely for you. We're going to demystify what makes the O-1 so powerful, why it's a rapidly growing pathway, especially for skilled professionals from India, and, what it really takes to qualify.
That's right. The landscape has definitely shifted. And for those with demonstrable expertise, the O-1 offers a direct route that bypasses many of the traditional bottlenecks. Understanding this option thoroughly is absolutely key for anyone with, well, extraordinary abilities looking to make their mark in the U.S.
Okay, let's unpack this then. When many of us hear O-1 visa, our minds might immediately jump to, I don't know, Hollywood celebrities or rock stars. But the data shows it's becoming a significant pathway for a much broader range of professionals. So what exactly is the O-1 visa, and why are we seeing such a surge in interest, particularly from talented individuals from places like India?
Well, what's fascinating here is that the O-1 visa is a non-immigrant U.S. visa specifically for individuals with extraordinary ability in their field. That ability needs to be recognized either nationally or internationally. It's distinctly different from other options like the H-1B, primarily because it's based on individual merit, not a numerical cap. And we should probably distinguish between O-1A, which is for those in sciences, education, business, or athletics,
Right.
and O-1B, that's for extraordinary ability in the arts or significant achievement in the motion picture or television industry.
That's a strong claim. Distinctly different.
Yeah.
Okay, for someone who's only heard, let's say, horror stories about the H-1B lottery, what specifically makes the O-1 more appealing, or maybe just less stressful as an alternative? Is it just the lack of a lottery, or are there other sort of structural advantages?
Oh, it's definitely more than just avoiding a lottery. Unlike the H-1B, which, as you know, faces annual limits and that random lottery system.
Yeah, the uncertainty.
Exactly. It leads to immense uncertainty and delays, even for highly qualified applicants. The O-1 visa, on the other hand, has no yearly limit, none. It's not subject to a lottery, period. So if you qualify, you can apply. That's the bottom line. Plus, it can offer significantly faster processing, sometimes in just a few weeks if you opt for premium processing.
Thinking and processing.
Yeah, that's an additional fee you pay to USCIS to expedite their review. And once it's approved, it allows for initial stays of up to 3 years, with extensions possible as long as you maintain that extraordinary ability status.
Yeah, that's a powerful distinction. So effectively, it offers a pathway based purely on merit and achievement, not just chance. That sounds like a game changer for many aspiring professionals.
Precisely. And this predictability, it's led to a significant increase in its adoption. Just look at the numbers. In fiscal year 2023, Indian nationals secured 1,418 O-1A visas. That's a staggering 191% increase from fiscal year 2020.
Wow, 191%.
Yeah, this makes them the third largest group of O-1A recipients globally. And to put it in perspective, the approval rate for O-1 visas is notably high, generally around 93%.
93% compared to H-1B.
Compared to roughly 37% for H-1B in recent lotteries, it's a huge advantage in terms of predictability and, well, success rates.
Okay, when I hear extraordinary ability, like I said, my mind jumps to Nobel laureates or movie stars. But those numbers you cited suggest a much broader application, especially for Indian professionals who, in reality, is getting these visas beyond the A-listers we might imagine.
You're right. That's the common misconception that it's only for the globally famous. But it's actually for people who have truly risen to the very top of their specific area of expertise. It's open to individuals from diverse fields: IT, science, medicine, education, arts, sports, business, entertainment, you name it. The key is demonstrating sustained national or international acclaim within your niche. It doesn't necessarily mean widespread household fame.
So recognition by peers.
Exactly. Recognition by peers, organizations, or media as someone who has made significant contributions to their field, which naturally raises the important question: what exactly constitutes extraordinary ability in the eyes of U.S. Citizenship and Immigration Services, USCIS? You don't need to be a global celebrity, like we said, but you must demonstrate that sustained national or international acclaim. It means you are one of that small percentage of individuals who have truly risen to the very top of their field.
Right, so if I'm listening to this and thinking, okay, maybe I have some extraordinary ability in my field, my next question is, how do I prove it? What kind of tangible documentation, what evidence are we talking about here?
Okay, so you generally need to meet at least 3 out of several specific criteria set by USCIS. For example, evidence could include winning a significant national or international award in your field. Think a major industry award or a research prize. Having publications in respected professional journals or maybe being featured in major media outlets about your work, that's another key one.
Media coverage counts.
Yes, significant media coverage. We also look for evidence of you serving as a judge of others' work in your field, perhaps on a peer review panel or competition jury. Or working in a critical or essential role for a respected organization, one with a distinguished reputation. Earning a high salary compared to your peers is also a strong indicator, as it suggests exceptional value.
So it's about demonstrating impact and recognition in concrete ways.
Precisely. And USCIS provides detailed guidance on how they evaluate each piece of evidence. They really emphasize the quality and significance over just the quantity.
Those criteria sound tangible, but I think listeners would really benefit from seeing them in action. Can you paint a picture with some real-world scenarios, maybe some less obvious examples of professionals who successfully used this visa?
Certainly. We've seen, for instance, senior software engineers with specialized skills, maybe in AI or cybersecurity, who've given talks at international conferences or published influential research. They've succeeded. Startup founders who've launched award-winning ventures, especially those covered in major tech media or perhaps funded by U.S. investors, they're often strong candidates.
Okay, so entrepreneurs too.
Absolutely. Think about artists and filmmakers whose work has won significant awards or been selected for prestigious international film festivals, or doctors and scientists with important published studies, maybe a high number of citations, or major recognition within the scientific community. Actually, a recent example involves an Indian senior R&D scientist in polymer sustainability. He secured O-1 approval in just 12 days using premium processing.
12 days?
Yes. His application showcased a really impressive record. 22 peer-reviewed articles, 2 book chapters, 382 citations, and over 110 peer reviews he'd performed for others' work. These examples, I think, underscore that it's about provable, consistent success and recognition within your field, not necessarily being a household name.
Right, provable success. Okay, so the path is clear for proving ability, which is fantastic. Now, if someone believes they qualify, how do they actually go about applying? Is it a straightforward process, or are there, hidden complexities?
Well, the process always starts with a U.S. job offer or a contract. That's fundamental because this visa is employer-sponsored. Your U.S. employer, or potentially an agent, files the petition on your behalf. They use Form I-129. They can file it up to 1 year before your services are needed, but ideally, it should be done at least 45 days before your employment start date, just to avoid potential delays.
Okay, so employer-sponsored. What are the basic steps someone needs to be aware of?
First, you secure that U.S. job offer or contract. That's step 1. Then you embark on what can be a meticulous process, collecting all that evidence of your achievements.
The awards, media, salary records.
Exactly. Awards, media coverage, high salary records, and crucially, recommendation letters from experts in your field who can really attest to your extraordinary ability. Now, while it's not legally mandatory, hiring an experienced immigration attorney is very highly recommended. They can help prepare a truly robust petition. Then, your employer files that Form I-129 with USCIS, along with all your painstakingly gathered supporting documents. This also includes something called a written advisory opinion, basically. A letter from a relevant peer group or expert in your field confirming your standing.
An advisory opinion, okay.
Yes, if the petition is approved, then you can proceed to schedule your visa stamping at a U.S. embassy or consulate in your home country.
That's a crucial point about the employer-sponsored nature. But you also briefly mentioned an agent can sponsor. That sounds intriguing, especially for certain career paths. Can you elaborate on the role an agent plays? And who might this option really benefit?
Right. The O-1 visa agent is a significant nuance for this category and quite useful. An agent can represent you for multiple employers or for short-term contracts. This is particularly common for professionals like artists, independent consultants, or maybe athletes.
People who don't just have one fixed employer.
Exactly. People who might work for various clients or on different projects over time. This allows for what's sometimes called a blanket petition. It gives you immense flexibility during your visa period. You don't need a brand new petition for each engagement. The agent acts as an intermediary, filing a single petition that covers all your planned activities and employers.
Wow, that's really flexible.
It really is. It's not
Never.
just some legal loophole. It
Yeah.
fundamentally reshapes career possibilities in the U.S. for people with more dynamic work lives.
That's a powerful distinction. Opens up a lot of possibilities. Okay, now for the entrepreneurial spirits out there, the really big question. Can you sponsor your own O-1 visa?
Yes. This is a crucial area, and there was a recent policy update around January 2025 clarifying this. While you, as an individual founder or owner, cannot directly self-petition for an O-1 visa, unlike some green card categories we might discuss later.
Okay.
A separate legal entity that you own, like a corporation or an LLC you've set up, may be able to file a petition on your behalf. However, and this is key, you must demonstrate a legitimate employee-employer relationship. Meaning there needs to be someone else or some structure within the company that has the authority to theoretically hire and fire you, even if you are the owner or majority shareholder. This clarification definitely opens up significant avenues for startup founders and innovators who might traditionally feel excluded from purely employer-sponsored visas. It offers a pathway for self-made success within the O-1 framework.
Got it. So possible, but requires careful structuring. Okay, the O-1 sounds incredibly promising for temporary work, offering really unparalleled flexibility in some cases. But for many, the ultimate goal is permanent residency, right? A green card. How does the O-1 fit into that longer-term immigration strategy? Can it serve as a bridge?
Yes, absolutely. It very often does. For many O-1 visa holders, the logical next step is applying for a green card through the EB-1A category. EB-1A is also for individuals with extraordinary ability.
Same term.
Exactly. Since the evidentiary requirements for the O-1 and the EB-1A are very similar, both focus on that sustained national or international acclaim. Having an O-1 approval can significantly ease the EB-1A process. It sort of pre-validates your claim, though the EB-1A standard is higher. And a major advantage of the EB-1A, unlike the O-1, is that it does allow for self-petitioning.
Meaning you don't need an employer sponsor for the green card itself.
Correct. Once you meet the higher bar for EB-1A, you can file the petition yourself.
Okay, so the O-1 can essentially be a strategic stepping stone. What are the key distinctions someone should keep in mind if they're planning that transition from O-1 to an EB-1 green card?
Well, while they're similar, the EB-1 standards are generally considered more intensive, more rigorous. They require considerable proof that you are truly at the very, very top of your field, often looking for evidence of a sustained career at that level, which might be beyond what's needed for the temporary O-1. And of course, the O-1 is temporary, requiring renewals, whereas the EB-1 offers permanent residency, the green card. Also, a big difference for families. O-1 holders, spouses, and children typically get O-3 visas.
O-3?
Yes, and O-3 status does not permit work in the U.S. In contrast, spouses and dependent children of EB-1 holders are granted green cards right along with the primary applicant upon approval, which includes immediate work authorization.
That's a huge difference for families. Okay, that brings us to a major pain point for many, especially Indian nationals. Those incredibly long green card backlogs in other categories like EB-2. How does the O-1, or perhaps the EB-1 path, offer a more viable route in that challenging landscape?
Yeah, this is a critical point if we connect it to the bigger picture, especially for many Indian STEM PhDs or professionals. While the EB-2 NIW, the National Interest Waiver, is an option for self-petitioning a green card based on work being in the U.S. national interest.
Right, we hear about NIW a lot.
Exactly. But it currently faces an incredibly long backlog, we're talking potentially decades, for Indian-born applicants due to per-country limits. However, securing an EB-2 NIW approval just to establish a priority date is a common strategic move.
What's a priority date?
It's basically your place in the green card line for that category. Once you have an approved petition, you get a priority date. It's yours forever, even if you change jobs or visa types later. So people get the NIW approved to lock in that date. Then the O-1, or maybe even a cap-exempt H-1B through a university or nonprofit research institution, can be a vital bridge.
A bridge while waiting.
A bridge to work legally in the U.S. while they continue building their profile, maybe aiming for the higher standard of EB-1A or perhaps EB-1B for outstanding researchers, professors, which have significantly shorter backlogs for Indian nationals. This difficult situation also leads some people to explore other, more complex options. For instance, marriage to someone born in a country without a backlog might allow for cross-chargeability.
Meaning they use their spouse's country quota?
Correct. They can use their spouse's country of birth to bypass the long Indian backlog. Or some even pursue Canadian permanent residence first, which could eventually give them access to TN visas for working in the U.S. under USMCA-NAFTA, offering another temporary work pathway. It highlights the lengths people go to navigate these backlogs.
Wow. It really paints a picture of the complex strategies involved. Okay, this has been an incredibly insightful deep dive into the O-1 visa and its place in the broader U.S. immigration landscape. For you, our listener, who might be envisioning a career in the U.S., what's the ultimate takeaway here? What are the key suggestions, maybe cautions you should carry forward from this conversation?
Well, to summarize, I think the main point is, if you genuinely believe you have extraordinary ability in your field, the O-1 visa is a powerful and frankly often overlooked alternative to the traditional options. It offers more flexibility and, crucially, entirely bypasses the H-1B lottery system. Our discussion today really underscores that the key is to start early. Start gathering strong, specific evidence and compelling recommendation letters. Don't wait. Be honest about your achievements and highlight your real impact using specific numbers, statistics, concrete awards, tangible proof.
Specificity matters.
Absolutely. And most critically, I'd say work with experts.
Yeah.
Whether that's experienced immigration attorneys or specialized consultants, find people who truly understand the nuances of the O-1 and related visa categories. Their guidance can significantly increase your chances of success. Remember, meticulously building your resume and portfolio, really showcasing your contributions to highly influential projects or work that will be invaluable, especially if you foresee potentially transitioning to permanent residency down the line, like through the EB-1. It's about recognizing your value and strategically positioning yourself.
So the takeaway here seems to be that while the O-1 offers clear advantages, it definitely demands a proactive and meticulous approach. You need to document your career impact thoroughly, especially with an eye on those future immigration goals. It's about recognizing your own value and then strategically positioning yourself to prove it.
Absolutely. Don't let the traditional visa narratives or the lottery odds limit your ambitions. If your work truly speaks volumes, the O-1 could very well be your direct path. Invest the time and effort in showcasing your extraordinary ability today.
Fantastic advice. Thank you for listening to this deep dive, and we will meet again with another important topic.